I am pleased to welcome my colleagues, Laura Windsor and George Koliopoulos. Laura is the chair of Williams-Mullen's Labor, Employment, and Immigration section. Laura's focus practices on representing businesses in employment and employee benefits litigation matters in state and federal courts across the country, and her employee benefits litigation experience includes the defense of disability, life, and health insurance claims under ERISA and state law. George's practice focuses on employment litigation, and he advises clients on a broad range of labor and employment matters, including developing and managing company policies and employment contracts, the creation of employment handbooks, drafting and implementing terminations and reductions in force plans, and executive and employment agreements. Laura and George, take it away.
Thank you so much, Carrie. Yes, that is us, and we can go to the next slide, please. It's really just a privilege to be with you guys today. Nothing better than spending the morning with 345 of your closest friends. So we're very happy to be here with you this morning. You might be wondering, my goodness, why are we talking about something like wage theft now? Is that even a hot topic? I will tell you, given the activity we've seen among state legislators, federal agencies, and most certainly private plaintiffs' attorneys, the answer is a resounding yes. The landscape of independent contractor misclassification specifically, and resulting claims of wage theft have changed considerably over the past couple of years, and the floodgates are certainly wide open on litigation. So I'm hopeful that over the next hour that we spend together, you'll have a good understanding of the issues and can help to minimize your risk. So what we're going to talk about this morning, you can see the agenda. First, we're going to talk about this changing landscape that I'm referring to of state and federal laws. I'm going to focus on federal law. George is going to focus on state law. We're going to discuss specifically how independent contractors are looked at under federal law, and then we're going to focus on a couple of states in our region. We're going to look at Virginia, Maryland, Washington, D.C., and North Carolina. And then we're going to analyze, well, how does independent contractor misclassification actually result in something called wage theft? And what the heck is wage theft? And liability. And then we're going to look at how joint employment issues are implicated here, how when one company becomes a de facto employer of the independent contractor. So let's go to the next slide. And what is really this so-called changing landscape, and why is that happening now? And I guess the first thing to realize is that the changing landscape is absolutely not limited to wage and hour laws. We're going to be talking about that today, but I want you to kind of stay a little bit at the 30,000 foot view for a second as well, and think about the changing landscape more broadly among various kinds of employment laws. So, for example, at the state and federal level, just generally, there is an absolute push for more worker protections and rights across the board. This certainly includes the increased scrutiny on proper classification of employees. It certainly includes the stricter wage theft laws that we'll be talking about today, but it also includes things like increased minimum wage. We're even also seeing more attention to child labor law issues that we haven't seen in years. Talking about minimum wage, I mean, think about the fact that many states are automatically increasing their minimum wage every year. I mean, for example, in Virginia, on January 1st, our minimum wage is going to automatically go up to $12 an hour. There's also a lot of increased attention on discrimination enforcement, pregnancy leave protection, FMLA issues, childbirth issues. And so we're just seeing a lot more attention on worker protections and workers' rights. Now, obviously, why you guys are here today is to talk about independent contractor misclassification. And this is just getting, as you'll hear me beat the horse over and over and over today, this is getting so much attention because it is denying workers pay and it is denying them benefits. And when we talk about independent contractors, we're talking about people who are classified as 1099 workers as opposed to W-2 employees. And this is having a remarkable effect, according to various state and federal agencies, on the loss of tax revenue. And if there's one thing you should know is that governments want their taxes. And so, in fact, in Virginia, as you'll hear, the loss of tax revenue was one of the major impetuses for bringing new Virginia laws on independent contractor misclassification. There's also an extremely heavy focus on the construction industry in particular, and we'll touch on that a bit. We're also seeing a lot of interest in independent contractor misclassification in the undocumented immigrant community. There's a lot of reasons for that, but I think one of the most prevalent ones is it's a lot easier for an undocumented immigrant to get a tax ID number, to be able to be issued a Form 1099, where they can't get a Social Security number, which would be needed for a W-2. So that is definitely of increased interest. And then, of course, there's the push for more worker protections that we've seen as an increased interest in labor unions. If you just read the news, you will see frequent attempts at organization at various retail establishments, Starbucks, Amazon, local Apple stores. Earlier this spring, President Biden made a speech that highlighted his commitment to push for more workers' rights, more increased protections to workers, and very aggressive enforcement of labor laws. There's a law that's been pending in the US Congress, and it really hasn't gone anywhere, and maybe it never will, but it's called the Protecting the Right to Organize, or PRO Act. So I will tell you, it is an absolutely fascinating time to be an employment lawyer. Their laws across the country are just changing so frequently. We never have the same day twice. And as we'll talk about it in a minute, for example, the Trump administration ended many policies and initiatives of the Obama administration. And now we're seeing the same seesaw where the Biden administration is undoing a lot of the initiatives of the Trump administration. So next slide, please. So let's get into the meat of this, worker misclassification, and what the heck I mean by that. What is an independent contractor? And if I say Joe's an independent contractor, is that enough? So next slide. When we talk about misclassification, we're really talking about two different things. And of course, we're going to focus on the latter today. But when you think about misclassification, there's really two concepts that come up. The first one is misclassification of exempt workers versus non-exempt workers under the Fair Labor Standards Act. Now, George and I could spend another hour or 2 hours telling you all about this. We're not going to do that today. Maybe that's going to be for another day. But to classify someone as properly exempt from the overtime requirements of the Fair Labor Standards Act, there's the salary level test. You must make at least $6.84 a week. There's the salary basis test. They must be paid a salary that does not change based on the quality or quantity of their work. And then there's a duties test. And that's usually the one where the rubber meets the road, the professional exemption, the administrative exemption, et cetera. If you hear nothing else from me today, at least hear that being paid a salary does not automatically make a person exempt from overtime. Like I said, this is a presentation for another day, but I did want to put that little worm in your brain to make sure that you're not merely classifying workers as exempt because they are being paid a salary. So misclassification of independent contractors versus employees is something that is relevant and touches on a lot of federal and state laws. And if you think of it this way, if you misclassify a worker as an independent contractor, there's all kinds of potential for unpaid overtime, potentially going back 3 years. And think of it this way. How many of your exempt workers do you actually keep timesheets on? How are you going to know what they actually worked? Well, the Department of Labor will listen to whatever the employee says that they worked. And if you don't have the documentation to back it up, that's where we are. So polling question number one, everyone's attention, polling question number one. All right, true or false, a company can avoid misclassification liability with a well-written consulting agreement containing a provision clearly defining the consultant as an independent contractor as opposed to an employee. And just a reminder, if you've requested CLE credit, you must respond to each poll to verify your attendance. So submit your response and we will let them roll in for a second. All right, we've got about 90%. Oh, I'm seeing so many smart people out there. This is terrific. All right, so as 79% of you have noted, it is correct that a well-written consulting agreement has absolutely no bearing on misclassification liability. The answer is false. A company cannot avoid misclassification liability with a consulting agreement. So anytime you have a consulting agreement and you're like, haha, I've got this, this is great, no one can touch me, please rethink that. Okay, let's move to the next slide, please. All right. So very broad brushstroke, and George is going to get into the details on some of the state-by-state dynamics, but what is the test for whether a worker is an employee or an independent contractor? And unfortunately, it really does vary by state. We have some federal law that governs, as I'll talk about a little later, but really states have a lot of laws as well. And remember, when you have a conflict between federal law and state law, whichever law provides the most protection to the worker is the law that governs. So there is a presumption generally that people performing work for a company are employees. It is largely dependent on the degree of control over the manner of means of doing the work. So just generally, the factors that go into control, are you telling the person where to be? Are you telling them when to be? Are you telling them when to report? Are you setting them work hours? Are you assessing how they perform the job? Are you assessing the quantity or quality of the work? Are you providing the tools for them to do their work? For example, are you giving them a desk, a computer, an email address, a cell phone, a monitor, which is the same thing that you're giving to all of your employees? These are all indicia of the control that a company might have over the independent contractor. So again, having an independent contractor agreement is absolutely not dispositive. Also, someone being hired as a, quote, temp is also not dispositive. They can be employees as well. So when you think of independent contractor, I really want you to think about the HVAC repairman that comes to your house, or the refrigerator repair person who fixes your refrigerator. They are coming in with their tools. They're coming whenever the heck they want to come, and they're fixing your refrigerator and then they're leaving. All right, next slide, please. Oh my gosh, why the heck am I talking about California? Because everyone knows that California is the extreme, and there is no difference here in misclassification issues. California has the most extreme test on independent contractor classifications. So as I tell many of my clients, if you have employees in California, make sure you have good HR and legal support because there are so many laws. But I bring this up because in 2019, California passed this Assembly Bill 5, which codifies what's called the ABC test. And you'll hear a lot more about this. It is the most stringent misclassification test in the country. So you can only be classified as an independent contractor if all three of the following are met. A, the worker is free from the control and direction of the hiring entity in connection with the performance of work. So again, no control. B, the worker is performing work that is outside of the usual course of the hiring entity's business. So think about a plumber performing services for a retail establishment. If a plumber is performing services for a plumbing company, that is not outside the usual course. And then C, the worker is customarily engaged in an independently established trade, occupation, or business of the same nature as the work performed. And what this means is that the contractor's business exists separate from its engagement with the company. So perhaps it's already incorporated, it's already been formed as an LLC, it's got its own license, it does its own advertisements, it exists as its own entity, it is customarily engaged in that established trade. Now, there are currently 33 states that have tests similar to the ABC test. Why I mention it today is because the ABC test is supported by the Biden administration as a national standard. And we'll talk about it in a second, but the Biden administration just approved proposed regulations from the DOL to create an independent contractor standard that is nearly identical to the ABC test. That will be published soon, and then there will be a notice and comment period, and then we will have final regulations. Okay, next slide, please. So before I turn it to George for state laws, I just want you to kind of reflect on what the government has reported are the impacts of independent contractor misclassification and why they are so aggressive about these laws. The harm to workers, that they have obviously no wage and hour protections, no overtime rights, no protection from discrimination and harassment laws. Remember, Title VII of the Civil Rights Act only applies to employees. It does not apply to independent contractors. So if they were subjected to racial harassment, they have no right of action there as an independent contractor. There are no parental or sick leave rights, no FMLA, no USERRA, no benefits, no workers' comp, and no unemployment insurance protection. And as I mentioned, the government is very concerned about its lost tax revenue that are coming from not withholding certain payroll taxes, Medicare contributions, unemployment taxes for the industry. And then ultimately there's harm within the industry. And I'm sure some of you have experienced this. A non-compliant company really hurts a compliant company. So non-compliant companies can underbid those who do properly classify their workers. And that's creating a competitive disadvantage where if you do the right thing, you maybe are less likely to get the big contract. So that is an issue as well. So let's turn it over to George, and he can tell us a little bit about how the various states in our region look at some of these issues.
Thank you, Laura. So first we have Virginia. Virginia recently enacted a misclassification statute, and like some of the other states or several of the other states that are following not exactly the California test, but a test that creates a presumption that if an individual is receiving money from a company that employs people, there's a presumption that that person is an employee as opposed to an independent contractor. Therefore, the burden is on you, the employer, to prove otherwise. So Virginia uses the IRS factors. Those can be found on the IRS website, but they can be distilled down to three main factors. You've got the behavioral control, as Laura mentioned before. You can't paper this away. You have to look at, what is this individual doing? Are they being controlled by someone that works for the company, that works for the employer? Obviously, clear-cut example of an independent contractor is you have a nursing facility hires someone to come in and paint the walls. That's an independent contractor. Less clear example is you sell products and you outsource a call center, and those individuals, arguably are employees. At least that would be the conservative approach. Then you look at the financial control. Does the worker benefit from his own business, cover their own business expenses, provide their own tools, enjoy profits, suffer losses? What is the risk that this person has? Are they wearing a shirt that has your company's name? That's never good. Then they look at the relationship of the parties. Does the independent contractor get benefits? If you're classifying them as independent contractor, chances are you're trying to avoid paying them benefits, but that's one thing that they look at. And then, as I said, the connection of the services. Are the services that this person is providing integral to your business? Could your business model work without this person? That's usually a nice litmus test. So Virginia is interesting in that the Virginia Department of Taxation investigates misclassification issues, and they have the power to impose civil penalties, and the statute also allows for a private right of action, and we will get into damages later. In my experience in dealing with the Virginia Department of Taxation is they will send you a lovely letter and says, it's almost like a congratulations, you've been selected for a tax audit. And they will list various categories of information that they'll request from you, such as payroll ledgers, your withholding tax returns, lists of any other subsidiaries that you own in the state, cash disbursements, W-2s, 1099s, bank statements. I'm speculating, but it's interesting, but it seems almost as if they're saying how much possible money there is there before they get into the duties test and find exactly what are these people doing for you, and are they in fact properly classified. It's almost as if, they're saying how big is the fish, and then they attempt to catch it. Next slide, please. Oh, yes, and then we have DC. So DC has adopted the California ABC test. And as Laura explained earlier, when you hear the word California or see the word California, there should be, let's call it a progressive sound going off in your head of, we probably should pay a little closer attention to this law. So DC is interesting in that you have the Office of the Attorney General investigating a lot of these lawsuits. So the OAG, Laura explained the ABC test, but DC's Attorney General's office has been really cracking down on misclassification. For example, they've in 2021, they sued a drywall company for misclassifying its workers. That case settled for just over $1 million. They went after an electrical engineering company, and that case settled for just over $2.5 million. So the Attorney General's office in DC is not playing around. As you can see, they've been focusing a lot on the construction industry, but they've also been focusing a lot on the gig industries, like the food delivery services. If some of these companies have been allegedly taking the tips that customers have thought were going to the gig workers. There's also classification issues with those gig workers of, are they employees or are they independent contractors? Like I said, could the business model work without these people? You draw your own conclusion. Next slide, please. So Maryland also applies the California ABC test, but Maryland is a little different from DC in that you're seeing more private rights of action in Maryland. But like in DC, like in Virginia, there is a presumption that the worker is an employee. If there's a violation, the employer will have to pay restitution to the affected of employees. But if there's a private right of action lawsuit, then you're looking at compensatory damages. You're looking at damages, unpaid benefits. You're looking at damages, for example, let's say your employees normally get health benefits, such as insurance, and this person gets injured or has some medical emergency that causes them to have to go to the hospital and incur a bunch of medical costs that otherwise would have been covered by insurance if they were properly classified as employees. Now the liability dollar sign should be going up in your head. Next slide, please. Now, Maryland does have an interesting way to attempt to overcome the presumption, and I'll talk about the liability later. But the requirements are as follows. If there's a written contract between the employer and a business that describes the work to be performed by the entity, describes the pay for the work performed, and acknowledges that the entity, not the employer, so the independent contractor, will uphold obligations to pay payroll taxes, unemployment insurance, maintain workers' compensation for their employees, and otherwise be responsible for their own employees. So they're really, putting this to the test. If you get into an independent contractor relationship that probably falls into the gray area in Maryland, you may want to check with your independent contractor that they have all these things, or put in the agreement provisions that if they don't, they will indemnify the company, hold the company harmless, and otherwise protect the company from a possible independent contractor misclassification lawsuit. Oh, the independent contractor also has to sign an affidavit affirming its independent contractor status and certifying its ability to work for other entities. That's one of the other many factors that courts would look at, is the ability to work for other entities, even competitors of the company that the independent contractor is providing services for. Let's look at North Carolina on the next slide. Largely governed by case law as opposed to statute, unlike the other states and the District of Columbia that we talked about. At a high level, a true independent contractor in DC is someone who's engaged in an independent business requiring the independent use of skill and knowledge and training, is doing a specific piece of work pursuant to a contract. So not on a weekly basis, not on a monthly basis, but on a project by project basis. And they're paid a fixed price or a lump sum, not a salary. So your monthly consultant fee of $5,000 or $10,000 every month is not going to cut it. They're paid at a fixed price, is not subject to that person's control regarding the way the work is performed and what must be done as the work progresses, and decides when and how to perform the services. So basically a lot of the IRS factors that governs the Virginia statute. And I'll hand it back over to Laura on the next slide.
Yeah, thanks, George. So I mentioned earlier the pendulum swing, the seesaw effect, however you want to look at it. But it has been, it's been like watching, a tennis match, the bouncing back and forth. But when we were under the Trump administration, barely under the Trump administration, the Department of Labor issued a new rule in January 2021 that somewhat loosened the Department of Labor's independent contractor test. And the reason for this came from a lot of individuals who wanted to be classified as independent contractors. They wanted to have that freedom and didn't want companies to have to treat them as employees, didn't want to didn't want to have those kinds of restrictions. And of course, businesses were pushing for being able to have the freedom to have independent contractors versus employees. So the Trump test, which again was barely a Trump test because it was right at the end, focused on two core factors. Only with the nature and degree of the worker's control over the work. So did the worker, instead of looking at the employer's control, it's now flipped and it was looking at the worker's control. Do I, as the worker, have control over my work and how I do it? And then the worker's opportunity for profit or loss based on the worker's own initiative or investment of resources. And in this regard, kind of going at, do I get more money for the amount of work that I'm doing? Am I suffering a potential loss if I don't do the work correct? And there was really a conflict between, if there's a conflict between these two factors, do you look at anything else to evaluate whether there was, for example, the amount of skill required for the work, how long the working relationship was, and whether the work was a part of an integrated unit of production of the employer's business. Let me take a second on that degree of permanence of the working relationship, because I do see this come up quite a lot. If you do have an independent contractor properly engaged with your company, they should not be there long. I sometimes see clients that have independent contractors that have been there for years, and you have to ask why. Why do you need this? Is there a specific project that they're working on that happens to take a year? Maybe that's the case, and they're engaged on this project and then they leave. But when you classify someone as an independent contractor, it really needs to be that direct coming in for a particular task. Remember my HVAC repair person, and then they leave. And so one of the things that I caution you to look at is the degree of permanence of that working relationship. So let's go to the next slide, please. So the first thing that happened when Biden took office was to attempt to rescind the Trump DOL rule. Okay. So the U.S. Secretary of Labor, Marty Walsh, was quoted as saying, by withdrawing the independent contractor rule, we will help preserve essential workers' rights and stop the erosion of worker protections that would have occurred had the rule gone into effect. Okay. So almost immediately, the Trump rule was rescinded. Oh, but then what happens? A federal court in Texas blocked the Biden administration from rescinding the rule. Did I tell you how fun it is to be an employment lawyer? I mean, it is just never a dull moment. So you have this rule. About the second it goes into effect, it's rescinded. About the second it's rescinded, the federal court in Texas says, yeah, you can't rescind that rule. So technically speaking, right now, we have at a federal level, the Trump rule. Biden has certainly indicated a preference for the ABC test. And as I mentioned, it was really only just last week that the Biden White House just approved proposed Department of Labor regulations that, if implemented, would be a huge change. For those of you law nerds out there, remember that the regulation process is that the government agency issues proposed rules. Then there is a notice and comment period where they can receive comments from the public or agencies, other constituents. And then after that notice and comment period, they might make some revisions, and then they issue final rules. Only once the final rules are issued do they go into effect. So that is a work in progress right now, but it is anticipated that we will have some rules coming out in early 2023. But before I move on from this slide, I want to bring to your attention a couple of other agencies that have their hand in the pot. And I found this fascinating because you get to hear about all kinds of agencies that you rarely ever think of. Who regularly thinks of the Federal Trade Commission? Well, the Federal Trade Commission recently got into the mix and seeks to regulate misclassification of workers in the gig economy, in particular, on the grounds that making gig workers independent contractors creates unfair restraints of trade and puts workers at a disadvantage. So we might see some rulemaking come out of the FTC. And I'm not done yet. The National Labor Relations Board also has a lot to say about this. The NLRB currently has a case pending that would impact how the NLRB, the National Labor Relations Board, considers independent contractors. It's called the Atlanta Opera case for all of you law nerds out there that want to look it up. And so remember, the NLRB and labor unions, obviously, they have a vested interest in having more employees, less independent contractors. Employees can be members of unions, and they can be part of the collective bargaining process. So the question that the NLRB is looking at is whether we use the Trump rule, the Obama rule, the Biden rule, or something completely different. So next slide. So returning back to our beloved Department of Labor, that is usually the agency with which we deal with at the federal level on worker misclassification. In early of June 2022, the DOL had identified worker misclassification as one of the most serious problems facing not only employees, but employers and the economy at large. And when the DOL, which is tasked with enforcing all kinds of laws, says that worker misclassification is one of the most serious problems, you kind of have to pay attention, that they're very mobilized right now to do something. As I mentioned, a lot of independent contractors actually want to be independent contractors. And so you might have to work as a company when you're trying to avoid this liability that we're going to talk about to really push them to understand why being an employee might be better. One thing that a lot of independent contractors don't realize is that as independent contractors, they are responsible for paying all of their taxes, all of their FICA. There is no withholding. And so to the extent that you need a little bit of nudge to help a worker understand why you're reclassifying them as an employee, the tax nugget is usually a very good one. But over the summer, the Department of Labor has been holding a lot of forums for workers and employers to purportedly, sorry, that sounded cynical. I didn't mean it like that. To purportedly be part of the process to rewrite these DOL rules to be more protective of workers. But where I really think the rubber is going to meet the road is when we get that into the notice and comment period. So let's go to the next slide, please. This is where we're going to start talking about wage theft, but ding, 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 it's polling time. So let's put up a new poll, and remember CLE, you love CLE, that's why you're here apparently, other than the fact that you love Williams-Mullen, remember that too. So the question is, wage theft means, true or false, wage theft means when an employer improperly deducts money from an independent contractor's pay. It's a little sneaky of a question, I'll warn you. All right. Seeing the results start to come in. Polls are fun. Okay. This is like watching when you've got microwave popcorn. Once it starts to slow down, you figure you're probably done and you need to get the popcorn out of the microwave. So I'm going to pull the poll popcorn out of the microwave. And the vast consensus was false, that 75% said false, that wage theft does not mean when an employer improperly deducts money from an independent contractor's pay. And you guys are so super smart. That is correct. Can we go to the next slide, please?
So thank you, Laura. So wage theft in general, wage theft, as Laura explained just now, or as you probably gleaned from that polling question, wage theft is very broad. Wage theft is when an employer does not pay an employee what the employer owes the employee. You've got categories: independent contractor misclassification, failure to pay overtime, failure to pay at all. This always means hourly wages, salaries, but also includes things like overtime, earned bonuses, commissions, leave, and other benefits. So that means health benefits, participation in 401k. What would the employee, what would have that individual have gotten if they were an employee of your company as opposed to an independent contractor? And as we mentioned earlier, if that individual, for example, gets injured and incurs thousands and thousands of dollars in healthcare costs that would have otherwise been covered under an employee benefit healthcare plan, that individual could possibly recover damages for that. These are all often a product of employee misclassification. And it's detrimental to the public good because it decreases tax revenue and suppresses the spending power of the victims. Next slide, please. Virginia wage theft. So these recent amendments to the Virginia Wage Payment Act have given this statute a lot more teeth. So basically, it's given, previously employees had to go through an administrative process or make a complaint to a Virginia entity, and now they can go straight to the courts and file a lawsuit. It creates a private right of action for employees to sue for unpaid wages or other violations of this statute, such as timing of payment and deductions from pay. There's a 3-year statute of limitations on these claims, and it even allows for class actions. The state, though, such as the Attorney General's office, can still go after these and through criminal charges and civil penalties. Not only opens the courthouse doors, but also allows recovery of back wages, triple damages, 8% prejudgment interest, and the employee can recover their reasonable attorney's fees and costs. Can you turn to the next slide, please? So DC also has a wage theft law. DC wage payment and collection law is one of the most progressive in the nation and also one of the most aggressively pursued. It covers all monetary compensation, like Virginia. It's bonuses, commissions, fringe benefits, overtime premiums, and other types of compensation. Courts have found employers have violated the wage theft law by not paying salary or hourly wages, moving or relocation expenses, bonuses, but discretionary bonuses might not be, and I'll talk about that, severance or commissions. Oftentimes, there's a distinction between bonuses that are guaranteed when you meet a certain threshold and discretionary bonuses, and often this issue arises after an employee is terminated. So if you have a policy that says, you are subject to receive a discretionary bonus, and the employee is terminated before, being eligible for that, or before the discretionary bonuses are paid out, more likely than not, the company won't be liable for that discretionary bonus. If you have guaranteed bonuses, such as the employee meets a certain threshold or a certain sales quota, and they're eligible for a specific bonus as outlined in a policy, then you want to make clear in that policy that the bonus is not paid out after termination or resignation for any reason, or the bonus is earned. In order for the bonus to be earned, the employee must be employed by the company. Now, the Department of Labor or whatever agency is pursuing this claim, they may very well take the position that if they did the work and they met the threshold, they're entitled to that bonus. And again, class and collective actions can exponentially increase the damage award. In my experience, I've seen cases where, the employer has shown that the fines imposed by the governmental entity not only could, but would bankrupt the company if they, paid these out, and the entity is still aggressively pursued their claims. Let's look at Maryland. So Maryland, like some of the other states, the government issues penalties and there's a private right of action liability. If an employer unknowingly misclassifies an employee, but comes into compliance within 45 days after being issued a citation, there can be no civil penalties, but you still have to pay back pay. Also, what does knowingly and unknowingly mean? That's a case-by-case, those are assessed on a case-by-case basis. I suspect that they would take the position that if it's in the gray area and it could go either way, and it's your first time violation, you probably have a good argument that it was not knowingly. If the employer does not timely come into compliance, then there can be civil penalties of $1,000 per employee that was improperly classified. And if they find that you knowingly misclassified employees, they can go up to $5,000 per employee. And similar to Virginia, if the employee brings the action, you can be responsible for attorney's fees and costs, triple damages, and other related damages. Can you turn to the next slide, please? So in North Carolina, if an employer is found to have misclassified an employee, the employer can be liable to the employee for unpaid wages, including overtime. So similar to the other states, liquidated damages, double damages, and reimbursement of reasonable attorney's fees and costs. Also subject to penalties for unpaid taxes, unemployment insurance, and 10% penalties from the North Carolina Secretary of Revenue. There's also a technical record keeping violation liability of $250 per worker for a maximum of $2,000 paid to the North Carolina Department of Labor. All right. Let's turn to the next slide and do a poll. All right, true or false? A company can avoid, true or false? A company can avoid misclassification and unpaid wage liability by engaging independent contractors through a staffing company and requiring the staffing company to indemnify it against any and all employment claims. Give you all a few minutes to give me your answers. Laura, would you mind reading me the results, because I accidentally exited out of the poll and I don't know how to get it back.
Oh, George. Be happy to. The popcorn has stopped popping. We are at about 88% participation, and the vast consensus, 85% of respondents said false.
And that is correct. While the agreement between the independent contractor and the entity certainly would be part of the evidentiary record, it's not dispositive. As we mentioned earlier, people look at the duties, and when we get into these joint employment issues that I'm about to talk about now, you'll see that that's not everything. Can you turn to the next slide, please? So joint employment in the misclassification context, you typically see joint employer issues where there are two entities involved, both of which employ people. And there's a number of factors that go into assessing whether one or both companies are liable. So if the court imposes joint employer liability, all those damages and all those civil monetary penalties that you heard us describe earlier, your company can also be responsible for those. For example, let's say you have a skilled nursing facility, and that skilled nursing facility has contracted with a staffing agency to provide skilled nurses or other individuals to provide services for the skilled nursing facility. And one of the skilled nursing facility employee, or one of the staffing agency's employees, brings a misclassification action against both. There's a number of factors that are going to be looked at. If you could turn to the next slide, please. So there are generally 5 factors, such as the control the potential joint employer had over those workers. So they'll look at, who disciplined the workers? Who chose the workers? Who had the authority to hire or fire them? The workers' ability for profit loss in their investment in the business of the supposed joint employer. Again, that's more in the individual context. The degree of skill and independent initiative required to perform the work, the duration of the work relationship, and how the work fits with the alleged joint employer's business. You consider the total weight of these factors, there's not one factor that can answer the joint employer question for you. However, in my experience, one of the main factors that is focused on is the degree of control and who truly supervises the employees. That is really the litmus test. So going back to our staffing company example, let's say you have CEO of the staffing company is named Kim, and the CEO of the skilled nursing facility is Chris. Kim's in a deposition, and she comes out and says, well, Chris told me who I could hire and fire. If Chris told me that someone had to go, they went. Chris would give me the specific skills, and she also wanted to be able to supervise these people and control their hours. Well, then, chances are Chris is going to have some joint employer liability at her company. Next slide, please.
Thanks, George.
Yeah.
Yeah. So, I mean, I guess one question you might be asking yourself right now is, all right. Sorry, it looks like I was muted. They muted me. They didn't want to hear from me. But the difference, one of the questions that has come up is, well, when do the federal agencies care? When do the state agencies care? And the best answer I can give to you is they might care at the same time. We very routinely have companies that are under investigation by the State Department of Labor and Industry at the same time that they're being investigated by the Federal Department of Labor. Theoretically, the agencies are supposed to cooperate with each other, but you could absolutely be subject to investigation by both. And I haven't mentioned our beloved IRS, but the IRS also could be conducting its own investigation into unpaid payroll taxes and FICA. So I wanted to touch very briefly, and then I'll get to some questions that we have in the chat feature, but excuse me, in the Q&A feature. But I just wanted to highlight one difference. So under the Federal Fair Labor Standards Act, for joint employers, they're looking at whether the two employers formally or informally share that power to direct control. I know we've said the word control a lot today, and that's a really, really important word. Whether they share the power to hire and fire the employee or change the terms and conditions of employment. Again, how permanent is the arrangement between the two employers as to this shared working? Whether there's any control over one of the employers by the other, whether one company is actually controlling the other company, not just the worker, and who controls the premises where the work is performed. And then we're going to look at who actually controls and handles the functions of payroll, taxes, insurance, providing equipment, things like that. And if there's sufficient overlap between the two entities, then the Department of Labor and certainly the courts are more likely to find that there is a joint employment relationship. And again, what does that mean? That means that the aggrieved plaintiff or the government agency can go after both companies together under a theory of joint and several liability. Next slide, please. I just wanted to touch on this briefly because, again, it's why employment law is just so stinking cool to be able to have the honor to practice. And that is because under workplace discrimination laws, there's a different test for a joint employer. So you actually have to use different tests depending on what kinds of claims you're talking about. But under workplace discrimination claims for joint employers, you're looking at who had the authority to hire and fire, who supervised on a daily basis, who provides the equipment used and the place of work, who has the possession and responsibility for employment records. So who's holding all the records? What is the length of time the employee has worked for the alleged joint employer? Who provides training? And are the workers' duties for company A similar to the duties of the employees of company B? Is the employee only assigned to one of the supposed joint employers? And did the employer and alleged joint employer intend to have a formed employment relationship? So both of these federal tests, the DOL test, and this is like the Title VII test, look at the total picture and determine what that economic reality is with regard to the joint employer relationship. And I will tell you, we see joint employer issues come up very, very frequently. We mentioned previously about the attention that the construction industry is getting on these misclassification issues. And this is a perfect place to mention that because in that construction industry, think about this. You have a general contractor who has a subcontractor, who has another subcontractor, who maybe has another subcontractor, and that subcontractor is impermissibly engaging someone as an independent contractor, okay? Let's say that that independent contractor at the bottom of my rung here was misclassified. If you can establish joint employment, oversight, control, you could go up all of those tiers and ultimately have joint and several liability with the general contractor. Now in DC, there's actually a law that requires that the general contractor is joint and severally liable with all of the subs. But just as a matter of common law, if you think about it, when you have all of those tiers, you could break down those tiers completely because it's very often not the immediate subcontractor who's engaging the independent contractor who has the deepest pockets. The deepest pockets might be further up the rung. And so that's why joint employer is so important. Well, we have 5 minutes left and we have a ton of questions in the chat. So let me briefly kind of try and go through some of these quickly. So one question is, have we actually seen courts enforce a provision saying the worker must indemnify the company in the event of a successful misclassification claim? It seems like a court has found that there was misclassification. They'd be either to avoid that kind of provision as contrary to public policy. So I have routinely seen where usually where these matters come to us is that the individual has claimed that they were misclassified as independent contractor, and they claim all of the bases of liability that George had mentioned about back pay, bonuses, et cetera, et cetera. And so we very, very, very rarely, and in fact, I don't think I have ever seen a worker have to indemnify the company. The next question is there any authority on the maximum degree of permanence that should be used as a rule of thumb? Gosh, I wish there was. That would be so great if there was some rule of, I talked about the duration of the independent contractor relationship being one factor that you can look at. And that's what this question is referring to. So the answer is no, but as the company, I would want to make sure that the engagement with the independent contractor is actually tied to something that we can point to. It's tied to implementing a new software system. It's tied to replacing all the plumbing in the store. It's tied to something that we can show the actual necessary duration of the arrangement. So I will tell you, the next question is about talking about subcontracting and staff augmentation and how staffing services work. The key issue here is maintaining the separacy, the separation between company A and company B. So for example, if you are engaged with another company for them to provide workers to your call center, you would not want to discipline or hire or fire any of those workers yourself. If you have an issue with one of company B's employees, you call your rep at company B, you say, company B, you got to deal with Sally. Sally's doing this, Sally's doing that. You don't administer the discipline. You don't affect the terms and conditions of their employment. You basically just have them there, and that's the best you could do. There is no black and white answer here. It's literally just trying to do the best you can to overcome the factors that tend to go to joint employment. So one question is about the status of kind of these gig workers like Uber drivers, things like that work for multiple entities, can set their own hours. So the one thing to keep in mind is every situation is different. So for example, if an Uber driver is truly controlling their own hours, controlling what they are going to do, when they're going to pick up rides, what they're going to do for that particular day, and they're not under any kind of oversight, maybe they truly are independent contractors, but it's a fact by fact basis. And so that's why we're seeing a lot more attempts at regulation of those kinds of gig workers and the Uber drivers, for example, is because what the Uber drivers are arguing is that they do have, that they are subject to a lot of control by Uber. They tell them how to keep their car clean, how to, what mapping system to use, what to charge, where to go. And so it's really just going to be a fact analysis. But what I would anticipate is that we're going to see more direction from the federal government on these issues. Some states are already weighing in on it. No surprise, California has already weighed in on it. But we should reasonably anticipate, and again, this is what the Federal Trade Commission is really interested in right now. So I think I've got like literally 30 seconds left. So one question is a good one. Do I think that the indemnity clause from a staffing company's contract would be enforceable? I mean, it would be a separate action. It doesn't affect the joint and several liability, but then the company A could seek indemnification from company B for whatever costs company A had to pay, and they are normally deemed enforceable.
All right.
Yep,
Looks like we're coming up on the end
I
of our
think we
time.
are. I think we are.
Thank you all for joining us. You're now headed into a break. After the break, you'll hear from McGuire Boyd and Patrick Haynes on When It Hits the Fan, Managing Your Company's Response to Investigations and Litigation. That will be at 11 a.m. Thank you for your time and have a great day.